otherwise.
Welcome to FCPA Flash, the official podcast of FCPA Professor and moderated by Professor Mike Koehler. FCPA Professor is the leading source of daily FCPA news and commentary and the most authoritative source for those seeking to understand and apply the FCPA. To learn how FCPA Professor can elevate your FCPA knowledge, please visit www.fcpaprofessor.com. FCPA Flash is sponsored by the Red Flag Group. The Red Flag Group manages your integrity and risk profile, turning compliance into a competitive advantage. The Red Flag Group assists companies in developing and maintaining efficient and effective corporate governance and compliance programs and has a proven track record in providing integrity due diligence investigations in 194 countries.
Welcome to FCPA Flash. This is Professor Mike Koehler, and the guest in this episode is Philip Rohlik, a lawyer in the Shanghai office of Debevoise Plimpton, where his practice includes FCPA matters. Philip is also a contributor to the FCPA Update, a Debevoise publication that is consistently one of the best periodic FCPA publications around. Thanks for joining us today, Philip.
Thank you, Mike, and thanks for the nice words about the update. Just before I start, I just need to make clear that I'm speaking today in my personal capacity, and I'm not speaking on behalf of the firm. And also, obviously, nothing I say is meant to be legal advice. So, having given my proviso, I hope we can start our conversation.
Yeah, thanks for those qualifications. So the focus of this episode is largely going to be around the DOJ's so-called declinations. And since the DOJ announced its FCPA pilot program in April of this year, the DOJ has publicly released, in conjunction with SEC enforcement actions against three companies, Nortec, Akemi Technologies, and most recently Johnson Controls, letters to the media under the heading Justice Department Declination Letter, stating that the DOJ, consistent with its pilot program, would not bring enforcement action against those respective companies. Now, regarding these recent examples, you and your FCPA Update co-authors write that none of these companies truly benefited from not being charged with an FCPA violation that they did not commit. And it would seem that none of these cases can properly be called declinations, at least in the traditional sense, end quote. Can you elaborate on those points?
Sure. I mean, I think the main point we were making was that the parallel SEC enforcement actions, the NPAs in Akamai and Nortec and the cease and desist order in Johnson Controls, didn't include any allegations suggesting any U.S. nexus. And without U.S. nexus, there is not a violation of the anti-bribery provisions of the FCPA, so there is not anything to decline. I would add, actually, that the SEC allegations don't include any allegations that you could use to insinuate the U.S. nexus. If you look at the key energy settlement that just came out, there's references to emails sent to people in the U.S. Now, we could argue whether or not that sort of thing would establish jurisdiction, but it's something you could build an argument on, whereas in the three enforcement actions you mentioned, there isn't anything like that. It's also the case that if you work in this space, and personally, as someone who works in China, if you look at the allegations, they are actually something which are typical of things which are funded locally with local currency. So there's no reason to assume that funds went back and forth through U.S. banks and that kind of thing. So while it's true that the SEC did not need to include any U.S. nexus allegation for its purposes, for its cease and desist order and NPA, those are the facts we have. And since those are the facts we have, it's very hard to say that there was a violation committed because there was no jurisdiction.
So if there were no viable criminal charges based upon the only information in the public domain. And as you indicated, the only information in the public domain regarding those 3 enforcement actions is the SEC order, because while the DOJ so-called declination letters contain some, let's call it, procedural aspects of the investigation, such as voluntary disclosure, such as cooperation, there's no substantive allegations in those very short letters. So if that is true, that there's no information in the public domain to suggest viable criminal charges that the DOJ declined, why do you think the DOJ released these 3 letters over the last couple of months?
Well, I mean, I think I think there's a few possibilities. I mean, first of all, although this is the case with past actions, these companies had all publicly disclosed that they were under investigation, and it's very nice of the DOJ to send them a letter saying we've closed our investigation. And in that sense, it could be the case that the DOJ thought that the companies would also release the letters. It's also the case that the pilot program was recently announced, and at least I personally, and I think most people believed the DOJ when it said in the announcement of the pilot program that people would be able to get the benefit from self-disclosure, cooperation, and remediation. It could be that the DOJ wanted to use these cases as examples or as proof that such credit was available. Although I'm sure that in the future they'll be able to come up with better examples and examples that have some context behind them. I think potentially the most interesting thing is the underlying factual allegations of the SEC complaints, because the pilot program says, well, you have to remediate, and you have to self-report, you have to cooperate, and you have to remediate, but that only makes you potentially eligible for a declination. And to the extent that they release these, whether or not we think it's a real declination, it might provide some sense of what sort of allegations will get you, what sort of allegations they will consider declining on, as opposed to what sort of allegations are more serious and they'll only consider departing from the sentencing guidelines.
Yeah, and I've written extensively about these 3 so-called declinations on FCPA Professor, and I agree with you that perhaps these were not the best examples to use for the reasons you mentioned. Moreover, for listeners' benefit, the broader point is for years, there's been SEC-only FCPA enforcement actions against companies that did not also involve a DOJ component. And in those rather numerous examples, the DOJ never proactively sent out letters to the media sort of marketing a new program. Do you think marketing this new program, even though these examples, for the reasons you mentioned, were perhaps not the best examples, was part of the motivation of the DOJ in doing this?
Well, I think, I think you're right. I mean, in fact, even last year, I think most of the actions were SEC-only actions. I mean, I can't put myself into the mind of the DOJ, obviously, but, I do think that they are interested in making it clear to people that they meant what they said in the pilot program, which is that you get a benefit from self-reporting, cooperating, and remediating. And it could be that they saw these SEC enforcement actions as a way of doing it. It's just that the context for doing so is not clear in any of these cases.
Do you expect the DOJ to release similar letters in the future? And what's interesting, and you kind of just mentioned this, is last week there was a SEC-only enforcement action against Key Energy Services. the DOJ did not release the so-called declination letter there. Rather, what happened is sort of another typical way that we often see is that, I think it was in April of this year, the company just quietly noted in its SEC filings that the DOJ would not be bringing an investigation. So do you expect to see an increase in these so-called declination letters in the future, in which the DOJ sends these out to the media and then they're widely reported by those in the FCPA space?
Well, I mean, it's an interesting question, and Key Energy, I haven't actually gone back and checked the dates. I mean, the weird thing about releasing these three letters is that basically the investigations into the allegations were over at the time, or almost over at the time that they announced the pilot program. And it could be that Key Energy, that they had told Key Energy that they weren't going to do anything before they announced the pilot program. I assume that they will continue to release letters like this. First of all, because on their website they now have a declinations page, which would look pretty silly if there were eternally only three things on it. I think that from their point of view, it provides examples, at least from their point of view, of the benefits people receive from participating in the pilot program, and then from everyone else's point of view, it's a question of whether they're particularly useful as unofficial guidance, which is to say, if they just list the bullet points of what does cooperation mean that are in the pilot program, then they don't add anything to the pilot program. But again, if they do continue this practice, it'll be interesting to track the type of allegations that they decide to release letters about.
And how should FCPA practitioners, corporate counsel, and others in the FCPA space analyze these letters when they come out in the future? And I agree with you. I think it's reasonably likely, particularly after the Labor Day holiday and continuing throughout the rest of the year, that we're likely to see additional declination letters like the three we've seen. How should those in the FCPA space who are advising clients in this area, whether internal clients or external clients, analyze these letters?
Well, I think a lot of it depends on the context, and in the article you referred to at the beginning, I mean, one of our points is that there wasn't the necessary context for this type of thing. So if they just release a letter without any factual allegations, or if they just release a letter for an SEC action that has 3 paragraphs and barely any information, those are not particularly useful, I think. I think that practitioners and internal in-house people should be looking to see if there is any additional guidance on what does it mean to fully cooperate in these letters. And I think that it could be the case, although I'm not going to say this for sure, but it could be the case that once there is a critical mass of these letters, a company and their counsel can take a look at the types of allegations that are, in quotes, declinations, and then really factor that into their decision of whether or not to self-report.
And as you mentioned, analyzing information in the public domain and matching up what is in the public domain against what the FCPA's legal elements are, seems like a pretty basic, old-fashioned exercise. But it seems like certain commentators in the FCPA space really aren't doing that. And another question I'd like to ask you is what one FCPA commentator has suggested regarding this notion that we just can't look what is in the public domain concerning the Nortec for Akemi Technologies or Johnson Controls enforcement actions and draw conclusions from what's in the public domain. And this commentator invented what I'll call a speculative theory that seemingly helps to explain the DOJ's declinations. This commentator stated that the only information in the public domain that would be the SEC's order in these three cases is the product of negotiations between the SEC and the respective company. This means the company can seek to keep out facts which would point to criminal liability, reputational damage, or facts that embarrass senior executives. And there's no way to know if the facts laid out in the SEC order, per this commentator, are all the facts in the case that were known to the DOJ or even disclosed to the DOJ. And in conclusion, this commentator says to base an argument on this underlying premise puts a person on wobbly ground in analyzing these declinations. What's your reaction, having participated in both the internal investigation standpoint, the disclosure process, and the resolution process, to this theory for why we can't necessarily draw conclusions from the only information in the public domain?
Well, I have a couple things to say. I mean, first, I agree with you that that's how you should be drawing conclusions, and we should be able to assess what the U.S. government is doing based on the public record, absent very compelling circumstances. Secondly, I would say in these particular cases, I don't buy it, in the sense that what we pointed out in our article, and the most common commentary on these, I think, was the fact that there was no allegation as to jurisdiction, so there was nothing to decline. And I find it unconvincing to say that these are negotiated, and it's true that these are negotiated, but I find it unconvincing to say that there was a lot of negotiation with regard to a jurisdictional allegation, which is usually a throwaway allegation anyway. Whether it should be or not is a different question. It's interesting, I think, to compare these three to the BK Medical and analogic cease and desist orders, because if you're going to negotiate the language of these sorts of resolutions, there are various things you're going to be very concerned about, and I don't think that jurisdictional predicates are one. But it's interesting that in Nortec and Akamai and in Johnson Controls, the SEC and in the case of Johnson Controls, also the DOJ are pretty copious about throwing around the word bribery, given that bribery isn't charged. In one of them, they use the phrase bribery scheme, and in the DOJ letter for JCI, they say they're closing the investigation despite the bribery at the Chinese subsidiary. The use of the word bribery is the kind of things that companies like to negotiate. Why not say improper payments instead of bribery if there's not going to be an anti-bribery charge? So if the commentator was talking about that kind of thing, that's something I can see happening. I can't see it happening with a jurisdictional allegation. And again, if you compare to the BK Medical and analogic case, as far as I recall, and I haven't checked this, but they don't explicitly use the word capital B bribery in the allegations, but they refer to creating the risk of bribery or other improper conduct. So if you're concerned about reputational damage and that kind of thing, there's a question about how do you compare the resolutions in the declinations to the resolution where there was an actual NPA. So things are negotiated, but it's hard to use that as a rule to say, oh, they must have been right anyway.
Yeah, no, those are some excellent points, and consistent with my own observations, having participated in the FCPA resolution process myself. We all know that if there's some tangential facts that are found in an internal investigation, those tangential facts might not make their way into the actual resolution document, but to suggest, as this commentator did, that most serious allegations that could potentially give rise to criminal liability were simply left out. I just don't find that argument credible.
Yeah, I agree with that.
Yeah, and the final question I have sort of goes back to what you and your FCPA update co-authors wrote about these so-called declinations in these three cases. And you wrote that, and we've gone through the reasons why you believe this, that none of these cases can properly be called declinations, at least in the traditional sense. And that raises a big picture question, a question I've wrestled with for a couple of years now on my FCPA professor website, and that is, what is the actual proper meaning of the term declination? This is a term that has clearly become part of the FCPA vocabulary over the last 2 to 4 years, but it's a term that is really not defined. So what in your mind is the proper meaning of the term declination?
Sure. I mean, obviously, as you point out many times on your blog, there are lots of words in the FCPA space that no one knows exactly what they mean, things like foreign official and facilitating payment. But I guess I would describe 4 situations, 2 of which could be called declinations. I think the first situation is the one we were talking about, where there's no jurisdiction or the statute of limitations have expired, or because of the location of the evidence and witnesses or whatever, the DOJ would not be able to prove a case. In that case, they shouldn't bring any charges, and their not doing so is not a declination. The second situation would be if there is an arguable but weak case and the DOJ decides that it's better to use its resources elsewhere. I guess you could maybe call that a declination, but I wouldn't, because that's what you would expect the prosecutor to do anyway. The next 2 cases I'm going to talk about I think, would be considered declinations, which is the DOJ has a solid case against the company, but as a reward for self-reporting, cooperation, and remediation under the pilot program, they decide not to bring that case. That would be a declination, and that's what the DOJ is suggesting they did in this case. And then the last situation I think is the most interesting, which I think was a factor or needs to be a factor in declinations, but nobody ever talks about it, which is where the DOJ, or for that matter the FCC, has a solid case but decides not to bring an action because of mitigating factors, arguably, for instance, with the Garth Peterson issue, which isn't actually that dissimilar from JCI, or where there's policy reasons, based on a recognition of the difficult situations companies find themselves in, that this is not the type of thing we want to use the resources of the government to go after. That would be a declination as well. But in both those cases, a declination is where the DOJ has a solid case, but for other reasons decides not to proceed.
Yeah, and many conversations in the FCPA space are, in my mind, muddied because people are talking past each other and not using common definitions. So, thank you for providing those 4 examples of what you view as a declination, what may be an arguable declination, and then some of the stronger types. I think that was useful. Well, thanks for joining us today, Philip. Again, Philip is a lawyer with Debevoise Plimpton, in my estimation, one of the best FCPA law firms around. And today we've been talking about what Philip and his co-authors wrote in the firm's recent FCPA update publication regarding the so-called declinations. Thanks for providing your insight in this episode of FCPA Flash.
Thank you, Mike.
Declination. This is a term that has clearly become part of the FCPA vocabulary over the last 2 to 4 years, but it's a term that is really not defined. So what in your mind is the proper meaning of the term declination?
Sure. I mean, obviously, as you point out many times on your blog, there are lots of words in the FCPA space that no one knows exactly what they mean. Things like foreign official and facilitating payment. But I guess I would describe 4 situations, 2 of which could be called declinations. I think the first situation is the one we were talking about, where there's no jurisdiction or the statute of limitations have expired, or because of the location of the evidence and witnesses or whatever, the DOJ would not be able to prove a case. In that case, they shouldn't bring any charges, and their not doing so is not a declination. The second situation would be if there is an arguable but weak case and the DOJ decides that it's better to use its resources elsewhere. I guess you could maybe call that a declination, but I wouldn't, because that's what you would expect a prosecutor to do anyway. The other 2, the next 2 cases I'm going to talk about I think, would be considered declinations, which is the DOJ has a solid case against the company, but as a reward for self-reporting, cooperation, and remediation under the pilot program, they decide not to bring that case. That would be a declination, and that's what the DOJ is suggesting they did in this case. And then the last situation I think is the most interesting, which I think was a factor or needs to be a factor in declinations, but nobody ever talks about it, which is where the DOJ, or for that matter the FCC, has a solid case but decides not to bring an action because of mitigating factors, arguably, for instance, with the Garth Peterson issue, which isn't actually that dissimilar from JCI, or where there's policy reasons, based on a recognition of the difficult situations companies find themselves in, that this is not the type of thing we want to use the resources of the government to go after. That would be a declination as well. But in both those cases, a declination is where the DOJ has a solid case, but for other reasons decides not to proceed.
Yeah, and many conversations in the FCPA space are, in my mind, muddied because people are talking past each other and not using common definitions. So, thank you for providing those 4 examples of what you view as a declination, what may be an arguable declination, and then some of the stronger types. I think that was useful. Well, thanks for joining us today, Philip. Again, Philip is a lawyer with Debevoise Plimpton, in my estimation, one of the best FCPA law firms around. And today we've been talking about what Philip and his co-authors wrote in the firm's recent FCPA update publication regarding the so-called declinations. Thanks for providing your insights in this episode of FCPA Flash.
Thank you, Mike.
Declination, and then some of the stronger types. I think that was useful. Well, thanks for joining us today, Philip. Again, Philip is a lawyer with Debevoise Plimpton, in my estimation, one of the best FCPA law firms around. And today we've been talking about what Philip and his co-authors wrote in the firm's recent FCPA update publication regarding the so-called declinations. Thanks for providing your insights